Well, we're learning that Steve Bannon has struck a deal with special counsel Robert Mueller's team. Mueller had subpoenaed President Trump's former chief strategist to appear before a grand jury this week on Russian meddling and possible collusion in the 2016 presidential campaign. But now, Bannon has agreed to cooperate with the special counsel's team and will be interviewed in a less formal setting. Joining me now to break it all down, CBS News' legal analyst, Rikki Klieman. Rikki, what does it mean, first off, to be testifying in front of these investigators as opposed to doing this in a grand jury?
Well, when you go to investigators, Robert Mueller's team, you first of all, and most importantly, are not under oath. So you can't lay what we call a perjury trap for someone who is not under oath. And what is a perjury trap? It means to make someone go under oath and know that or assume that they just may lie. On the other hand, we also know from various cases, probably the most famous being Martha Stewart, that if you lie to a federal agent, and of course Mueller's team is filled with federal agents, and if you lie to a federal agent or a government agent, that you can be prosecuted for what we call false statements under the Section 1001. How do we also know that? Obviously, Mike Flynn's indictment or information that has been filed against Mike Flynn, George Papadopoulos's information that has been filed against him. It wasn't for them the doing of a deed, it was the cover-up of the deed.
When you talk about cover-up, there's sort of this air that somehow Steve Bannon is being a little shady by coordinating with the White House team about what he can talk about. Is that really the case?
No. First of all, the doctrine of executive privilege, whether it's dealing with what he could testify to or even say to Robert Mueller's team, but perhaps even more importantly, what he could say or testify to before Congress, the doctrine of executive privilege is really a very well-settled doctrine in the law. It's not in the Constitution. So that's what people always say, well, it's not in the Constitution, so why do we think that this is really settled? We know it's settled under the Supreme Court case of United States versus Nixon, which recognized that there is indeed a term of executive privilege. And what that means is that the president and other members of the executive should be able to act without fear that what they say in candor will be then somehow disclosed later on. The usual process is that an investigative body would go to the White House and say that they want to call, for example, Mr. Bannon. And among the things they would like to ask him are things that involve conversations with the president while he was president. Doesn't mean while it was during the campaign. But once he is in a presidential office, his communications are confidential with his advisors up to a point. It's a qualified privilege. It's not absolute.
How often, you mentioned Nixon, but how often have presidents in the past used executive privilege?
It's actually surprising when you look into it, because somehow we think that, oh, executive privilege, they're trying to hide someone, no one would ever do this. Well, Bill Clinton used it 14 times. George
14 times.
14 times. And of course, that one would assume that that was during the period of Ken Starr's investigation and the Monica Lewinsky scandal. We know that George W. Bush used it 6 times. And I think that we know Ronald Reagan used it back at the time of Iran-Contra. And I think importantly enough, what we may remember in more recent history is that the time that people got very angry throughout the country about its use was during the issue of Fast and Furious, when the Attorney General wanted to assert executive privilege. Now, it doesn't mean that you can assert executive privilege and keep someone from testifying altogether. It's only about those private communications that were given for advice by an assistant to the president, which Bannon clearly was. Now, these things could be done on a question-by-question basis. And then the decision rests with the president whether or not he wants someone like Mr. Bannon or Attorney General Sessions or others to assert executive privilege or not. In fact, the Trump administration decided they would not have Jim Comey use executive privilege, and they let him go forth and testify.
I want to play a bite from you from the White House press briefing, get you to react to the White House's response to this entire situation.
I can tell you that this White House is following the same practice that many White Houses before us that have gone back decades, that there is a process that you go through. Anytime you have congressional inquiries touching upon White House, the Congress should consult with the White House prior to obtaining confidential material. This is part of a judicial recognized process. We want to follow through that. We've been fully cooperative with the ongoing investigations, and we're going to continue to do so. And we encourage the committees to work with us to find the appropriate accommodation in order to ensure Congress obtains all the information that they're looking for. But there's a process this works through, and it's not just isolated to this instance. Executive privilege is something that goes back decades because it's something that needs to be protected, whether it's during this administration or 20 years from now. We want to make sure we follow the process and the precedent, and that's all that's taking place here.
What do you make of that?
She's correct. I know that people would really like the administration to go forth and say it has been saying it's transparent, so where's the transparency? Now people are saying, oh no, they're not transparent, they're hiding behind executive privilege, and there must be something bad there because otherwise they would let Mr. Bannon talk. At the same time, you have to understand if, in fact, this is the real reason for keeping Mr. Bannon's questions from being asked and answered at this time before a congressional committee, is that the process has existed for decades and should be followed correctly. The proof is in the pudding, as they say, because if the process is followed correctly, that then the White House is made aware of what they are looking for. Is the White House going to be transparent, as they've said they would be, and cooperate fully? Or are there areas that they're going to hold fast to executive privilege? Then we may have a different coloration on this issue.
Rikki Klieman, you make this all so digestible, such complex legal issues. Thank you for joining us, Rikki.
Thank you, Rena.